We are anonymous. No faces, no flags, no parties. We exist where power whispers to itself and assumes no one is listening. Tonight we are listening. And tonight we are exposing a system in panic, a Department of Justice scrambling for cover, and a former president whose favorite weapon has finally misfired. What you are about to hear is not opinion. It is not speculation. It is a stitched-together record of rulings, filings, court behavior, and documented defiance that reveals something unmistakable. Donald Trump's strategy of intimidating judges has collapsed, and with it the illusion that his Department of Justice is acting in good faith. Donald Trump has always treated the courts as obstacles to be bullied, not institutions to be respected. When he wins, the courts are fair. When he loses, they are corrupt. When judges rule against him, they are branded Marxists, radicals, enemies of the people, unelected tyrants. This has been his reflex for years, and Pam Bondi's DOJ has adopted that reflex as policy. The playbook is simple and cynical. Lose a case, ignore the ruling, attack the judge, flood the media with smears, file an ethics complaint to create fear and delay. The goal is never justice. The goal is pressure, intimidation, control. This time it failed. A ruling from the Sixth Circuit has now fully dismissed the ethics complaint against Chief Judge Jeb Boasberg of the D.C. District Court. Not trimmed, not narrowed. Dismissed outright, no misconduct, no evidence, no violation. Just a baseless attack exposed for what it was. And the dismissal matters because it shines a bright light on the desperation inside Trump's DOJ. Let's talk about who Jeb Boasberg actually is, because Trump world desperately wants you to believe he is some kind of ideological zealot. He is not. Boasberg is a moderate Republican. He was appointed by Barack Obama, yes, but also previously appointed by George W. Bush. He is an institutionalist, a rule of law judge. He is a friend of Chief Justice John Roberts. He once shared an apartment with Brett Kavanaugh. He is widely respected across ideological lines. As Chief Judge in Washington, D.C., he oversees grand jury matters and some of the most sensitive judicial functions in the country. In other words, he is not a rogue. He is the system Trump claims to defend, except he actually believes in it. 3 to 4 days before Boasberg was randomly assigned a case that would trigger constitutional alarm bells, he attended a routine judicial conference. These conferences happen twice a year. They are presided over by the Chief Justice of the United States. Judges from all 93 federal circuits attend. They discuss procedure logistics, policy, and threats to the judiciary. According to reporting later echoed by conservative outlets themselves, Boasberg allegedly expressed concern that a Trump administration might openly defy federal court orders. There is no transcript, no recording, no sworn testimony, no proof. But what followed made that concern painfully real. 4 days later, Boasberg was randomly assigned the case known as JGG. The case involved hundreds of Venezuelan men who were secretly rounded up and flown out of the United States in the middle of the night. They were not given hearings. They were not allowed to consult lawyers. They were not given the chance to challenge the accusations against them. They were deported under the Alien Enemies Act, a wartime statute despite the United States not being at war with Venezuela, and despite the men being accused not of being enemy soldiers, but alleged gang members. Boasberg ordered the planes grounded. The Trump administration ignored him. Those men were flown to El Salvador and dumped into CECOT, a prison internationally condemned for torture, brutality, and indefinite detention. Later, they were traded like bargaining chips in a prisoner exchange with Venezuela, a maneuver that conveniently removed them from Boasberg's jurisdiction. This was not immigration enforcement. This was calculated defiance. Boasberg responded the way judges are supposed to respond. He initiated contempt proceedings. He demanded accountability. He asked a basic question that any functioning democracy should insist on answering. Who gave the order to violate a federal court ruling? That question triggered panic. Each time Boasberg moved toward contempt, Trump's DOJ rushed to appellate courts seeking emergency intervention. Temporary blocks were granted, but the pattern was obvious. The administration was not trying to defend its actions on the merits. It was trying to outrun them procedurally. The Supreme Court eventually ruled that habeas corpus was the proper mechanism for review. That ruling did not bless Trump's actions. It simply clarified the path forward. And instead of following that path honestly, the DOJ took a darker turn. They did not move to recuse Boasberg for bias, because that would require evidence. They did not challenge him through proper appellate channels. Instead, they filed an ethics complaint. The complaint was submitted by Chad Mizell, then Chief of Staff to Pam Bondi, who has since exited the administration. That alone speaks volumes. This was not a principled legal effort. It was a political strike. and because the D.C. Circuit could not review its own chief judge, the complaint was sent to the Sixth Circuit, landing on the desk of Chief Judge Jeffrey Sutton. The DOJ made two claims. First, they alleged that Boasberg made an inappropriate comment at the March 11th judicial conference expressing fear that Trump would defy court orders. The court ordered proof. The DOJ provided none. No witness, no document, no sworn statement, nothing. That failure alone was fatal. Second, they argued that Boasberg's rulings violated appellate or Supreme Court precedent. Judge Sutton examined that claim and dismantled it. Ethics proceedings are not substitutes for appeals. Disagreement with rulings does not equal misconduct, and attempting to relitigate the merits of a case through an ethics complaint is itself an abuse of the system. Sutton's ruling was devastating to the DOJ's narrative. He made clear that even if the alleged comment had been proven, which it was not, a judge expressing concern about executive compliance with court orders during a judicial conference is entirely appropriate. Judges are allowed to discuss threats to the rule of law. That is not misconduct. That is responsibility. As for the second charge, Sutton was blunt. If you believe a judge violated precedent, you appeal. You do not smear. You do not intimidate. You do not weaponize ethics rules. The complaint lacked evidence. It lacked merit. It warranted dismissal, and it was dismissed. But the larger story kept growing. A CLU, Attorney Lee Gellert, explained publicly that the Trump administration's position was essentially that courts have no authority to review deportations under the Alien Enemies Act, that wartime powers can be used in peacetime, that people can be labeled gang members without evidence, that due process is optional, that judges should stay out of it. Men were sent to El Salvador in secret. Families later identified them through leaked videos. Some had no criminal records. Some were not gang members at all. DHS refused to provide documentation. The administration demanded blind trust while offering zero transparency. This was Guantanamo all over again. Inflated threats, dehumanizing labels, and quiet admissions later that the danger had been exaggerated or invented. Boasberg demanded answers. He ordered the government to identify who authorized the flights. The response was evasive. Declarations came from mid-level ICE officials with no direct knowledge. The government hinted at invoking state secrets. Boasberg called the response woefully insufficient. He demanded sworn statements from officials with direct involvement. The administration refused. This was not confusion. This was obstruction. Then came another revelation that shattered any remaining pretense that Boasberg's concerns were hypothetical. In a recent filing, Chief Judge Magnuson Schultz of the Minneapolis federal courts revealed that ICE violated court orders 96 times in January 2026 alone. 96 violations, 1 month. Schultz observed that this was likely more violations in a single month than some government agencies commit in their entire existence. Let that sink in. 96 times federal court orders were ignored. This is not a rogue agency. This is policy by defiance. So ask the question Trump does not want asked. Was Jeb Boasberg wrong to fear that a Trump administration would defy federal court orders, or was he simply paying attention? The Sixth Circuit has answered. The ethics complaint is gone. Boasberg is cleared, and the record now shows a DOJ willing to attack judges instead of obeying them. This is why Trump's DOJ is panicking, because Boasberg now has something Trump cannot spin away: judicial validation, institutional backing, and a paper trail of executive misconduct. If contempt proceedings continue, if sworn testimony is compelled, the story will no longer be about immigration. It will be about who ordered federal agents to violate court orders and whether a president can place himself above the Constitution. Trump has always tested institutions the way a burglar tests locks. When one holds, he screams corruption. But courts are not props. Judges are not subordinates. And the rule of law is not optional. Pam Bondi's DOJ tried to bully its way out of accountability. Instead, it exposed its own lawlessness. The intimidation campaign failed. The courts pushed back. And now the spotlight is fixed exactly where Trump never wants it. We are anonymous. We do not forget. We do not forgive abuse of power.